The second presentation will be made by Cristina Ruiz López from the University of Burgos. And she will present the violence against women and the sexual assault and the state's positive obligation in the light of the ECHR jurisprudence. So, floor is yours, Ms. Lopez.
Okay, good morning, everyone. Thank you very much, Professor Adem Souser and members of the Office of the Law on the Bosphorus Summer School for the organization of this essential summer school and for inviting me to participate. I'm delighted to be here, and it's a huge pleasure. Well, my name is Cristina Ruiz López, and currently I'm postdoctoral researcher in the University of Burgos, Spain. But since next September, I will head by University of Extremadura, Spain. Because of this change of the work of place, you have my personal email if you want to put in contact with me. The topic I would like to talk with you is about violence against women and sexual assault and the state's positive obligation in the light of the European Court of Human Rights jurisprudence. Therefore, we have 4 topics interrelated: European Convention of Human Rights, Istanbul Convention, European Court of Human Rights, its state's positive obligation and the so-called due diligence standard, and violence against women and sexual assault, sexual violence. 4 topics which correspond to different legislation, international and European legislation, and substantive and procedural national law, and jurisdiction, the judicial power, and political power represented by the states. That is the 3 powers in every rule of law. But also, violence against women appears as a social and cultural phenomenon which highlighted the importance and the role of society from an interdependence perspective: sociological, victimological, political, historical, etc. My presentation is articulated in relation to the need to answer to 4 questions. What is due diligence standard in relation to violence against women? Istanbul Convention has had any added value in relation to the due diligence by its states? Where and who determines whether a state has acted with due diligence? What happens if this obligation is not accomplished? I will try to analyze each one of these questions. What is due diligence standard in relation to violence against women? The requirement of positive obligation of on states is not a recent phenomenon in international law. If you read the report of the Special Reporter on Violence Against Women, its causes and consequences, Yakin R. Turk, you can access directly to the document in this link indicated in the slide. The due diligence standard has a long history in international law, and references to the standard can be found in the works of 17th century writers. In the 19th century, the standard was used in the context of several international arbitration claims, including the Alabama claims in 1871, concerning the responsibility of the state for the protection failures in relation to injuries to aliens and their property from private violence. This matter is important to highlight it: property. This principle implied that the state is obligated to act with due diligence to prevent, investigate, punish, and provide remedies for acts of violence, regardless of whether they are committed by private or state actors. Therefore, this standard is a historical tool for the human rights protection. In other regional contexts, also was formulated this due diligence on the state in regard to the accomplishment of positive obligations. For example, the decision of the Inter-American Court of Human Rights in Velázquez Rodriguez versus Honduras in 1988. Also, this standard was legally recognized on Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, 1994, called as Convention of Belém do Pará. I think it's important to appreciate that what the historical milestone on the different parts of the world. The European Court of Human Rights also used a due diligence standard in Osman versus United Kingdom case in 1998 and has since developed its case law in relation to obligation states to provide protection against human rights violation by non-state actors. This interpretation is called an Osman test to prevent violations of the right to life. In relation to violence against women, the committee monitoring the Convention on the Elimination of All Forms of Discrimination Against Women, called as CEDAW, is in its general recommendation number 19 in 1992 called on the states to act with due diligence to prevent and respond to violence against women. The 1993 requires the states to act with due diligence to prevent, investigate, and punish acts of violence against women, whether these are perpetrated by a state or private actors. This provision was reiterated in paragraph 125B of the 1995 Beijing Platform for Action. The due diligence on the accomplishment of positive obligation by the states is present in all the texts of the Council of Europe's Convention of Preventing and Combating Violence Against Women and Domestic Violence, Istanbul Convention, the first European legal instrument that regulated violence against women as a violation of human rights. In Article 5, state obligations and due diligence, it is said, 1. Parties shall refrain from engaging in any act of violence against women and ensure that the state authorities, official agents, institutions, and other actors acting on behalf of the state act in conformity with this obligation. 2. Parties shall take the necessary legislative and other measures to exercise due diligence to prevent, investigate, punish, and provide reparation for acts of violence covered by the scope of this convention that are perpetrated by non-state actors. We can ask, why this article is important? The answer is because it's a consequence of the historical importance of Istanbul Convention, because it directly and legally links due diligence to violence against women. It's important to know that the word legally, because the due diligence standard to measure the accomplishment of the positive obligations by the states had already applied by the European Court of Human Rights and other courts. The gender approach to violence is not itself new, having been recognized by the CEDAW Committee, other United Nations bodies and the European Court of Human Rights. Rather, the innovation is in dedicating itself to tackling this gender dimension and adopting tools to prevent, protect, prosecute, and combat it. The European Court first dealt with domestic violence in 2006 in Controva versus Slovakia case in relation to the killing of children. In 2009, the European Court dealt with its first cases of femicide, Branko Tomasic and others versus Croatia, and Opus versus Turkey. However, while the requirement of due diligence already existed in international law in relation to violence against women, the Convention is the first instrument to include the requirement explicitly in relation to violence. A pause to highlight the composition of the European and International Court, the International Criminal Court, the International Court of Justice, the Court of Justice of the European Union, and the European Court of Human Rights. As you can see, the integration of women as judges is something to think about and to improve in order to achieve equality between women and men. In 2019, we have this interesting example. In the case you can see in the slide, the International Criminal Court in 2019 found Mr. Bosco and Tangaganda guilty beyond a reasonable doubt of 18 counts of war crimes and crimes against humanity committed in Ituri, in Democratic Republic of the Congo. It was a landmark ruling condemning rape as a war crime and a crime against humanity. For the first time in history, a high-ranking military commander of the rebel troops, will be found directly responsible for the rapes committed by his troops. In other words, it proves the responsibility in the chain of command, and that sexual violence was a weapon of war in Democratic Republic of Congo. It is very important to note that this is a tremendous positive change on the eradication of violence against women in all contexts, war times and peaceful times. From the historical consideration of the sexual and gender-based violence as an inevitable product of war, to the current consideration of sexual and gender-based crimes as especially grave violation of international law. Why did it happen? slowly, and because of a social movement of women activists and some men who created a vocabulary. And there is a vocabulary because there is a framework, because there is a theory, because there is a social movement who has an agenda. We cannot speak about violence against women, gender perspective of any related theme or topic without highlighting this huge role of activism. So as we are saying, and it is stated in the document shown in this slide by Council of Europe, the jurisprudence of the European Court of Human Rights on violence against women played an important role in the negotiations of Istanbul Convention, which entered into force on 1st August 2014. Many of the issues raised by the court with regard to this case law are now codified as obligation on the parties of the Istanbul Convention. In fact, on the preamble of the Istanbul Convention stating, taking account of the growing body of case law of the European Court of Human Rights, which sets important standards in the field of violence against women. Since Istanbul Convention entered into force, there has been a mutual influence. The jurisprudence influenced it in the text. Currently, the text is interpreted by European Court of Human Rights jurisprudence. Therefore, in order to specify what the positive obligation of states in relation to violence against women consists of, we could divide it into before the Istanbul Convention in a broad territorial perspective, and after the Istanbul Convention in order to be able to appreciate whether it has added any value in relation to the eradication of this crime and the protection of the victims. Before the Istanbul Convention, internationally, in the report on domestic violence, the former special reported in 1999 developed the following list of consideration for determining state compliance with obligation of due diligence: ratification of international human rights instruments, constitutional guarantees of equality for women, the existence of national legislation on and/or administrative sections providing adequate redress for women victims of violence, policies or plans of action that deal with the issue of violence against women, the gender sensitivity of the criminal justice system and police, accessibility and availability of support services, the existence of measures to raise awareness and modify discriminatory policies in the field of education in the media, and the collection of data and statistics concerning violence against women. Also, you can find in this slide in the American system, the Inter-American Commission of Human Rights, in the case of Maria da Peña Maya Fernandez in 2001, that is interesting to find how evaluated the acts by Brazil, which leads us to point out some basic principles. The state cannot delegate its obligation to exercise due diligence. Related to this point is the notion that due diligence may imply extraterritorial obligation for states that are exercising jurisdiction and effective control abroad. Non-discrimination, which implies that states are required to use the same level of commitment in relation to prevention, investigation, punishment, and provision of remedies for violence against women as they do with regards to the other forms of violence. Due diligence obligation must be implemented in good faith. The idea of effectiveness with a view to preventing and responding to violence against women. This will necessarily entail taking positive steps and measures by states in order to ensure that women's human rights are protected, respected, promoted, and fulfilled. Accurate empirical data to ensure that interventions designed to prevent and respond to violence against women are based on accurate empirical data. There is glaring need to establish reliable statistics and indicators concerning violence against women and the evaluation of intervention designed to eliminate it. All of them are projected on the positive obligations subdivided into 4: prevention, punishment, and reparation. We will see how European Court of Human Rights interprets each one in the sphere of Article 2, right to life, 3, prohibition of torture, 8, right to respect for private and family life, And 14, prohibition of discrimination of the European Convention of Human Rights. The main consideration on which the European Court has been elaborating in relation to violence against women have been the requirement for state parties to assume positive obligations of a material and procedural nature, specifying what these obligations are depending on each article of the European Convention. The attribution of the state responsibility for acts of private individuals, the concept of due diligence linking to the previous 2 points. This point discusses the appropriate measure the legal system must provide for the examination of certain aspects of the merits of the case, for example, interpreting consent in sexual relations, vulnerability, or exposure to certain dangers. The determination of which articles of the European Convention are considered to have been violated by acts of violence against women. Following the consideration of the United Nations Special Reporter in her 2015 report, Rashida Manhu, the case law of the European Court of Human Rights has been determining the objectives of each article and what repercussions they entail. Prior to the concept of due diligence, state responsibility could only be predicated if the state could be held responsible for the criminal acts. Since the construction of the standard of due diligence, if the European Court understands that a state had to perform a positive obligation and has not acted with the degree of diligence, the violation of an article of the European Convention can be imputed to that state. Thus, the essential issue will be to determine the factual circumstances that characterize the act, what positive obligations were predicated on the state, and what measures the state took to satisfy the due diligence. The European Court has been outlining what is meant by due diligence, or reasonable steps, or reasonable effective measures, as it also calls it, according to each specific article of the European Convention. Thus, we can outline the following activities for the following articles, as you can read in the table. It's interesting, this table, because you can find in each article, Article 2, 3, 8, and 14, some case law specifying some word, for example, effective criminal law provision in order to protect the right to life, practical preventive measures, or procedural obligation, like, for example, attention to the slowness of criminal proceedings or delays. Even in Article 3 and 8, related to that circumstances of the case. Also, analyzing this legal framework of the national law and what is called effective exercise. And also in Article 14, with the prohibition of discrimination relating to the need to provide evidence in order to prove this discriminatory act. We can make some comments in this regard. Following the line of jurisprudence set out above, the positive obligation to prevent violence under certain circumstances extend to requiring the authorities to take preventive measures to protect a person from the criminal acts of another person, a requirement that is part of the material aspect of the particular right in question. State action is examined once the European Court states that the state's parties knew or should have known of the existence of a real or immediate risk. It is necessary to point out that, despite the margin of appreciation recognized to states, according to European Court in the case of MJ versus Turkey 2016, the Istanbul Convention integrates the standard of due diligence and defines it as an obligation of states to prevent, investigate, punish, and provide reparation for acts of violence perpetrated by non-state actors. In this sense, we must highlight the case law by European Court in the case of Baliulin versus Lithuania, in which it interpreted the concept of due diligence, taking into account the high number of cases of gender violence against women in certain societies, such as the Lithuanian society. The European Court has stated that the European Convention requires effective investigation, prosecution of the cases of violence against women and punishment of the perpetrators without undue delay. Requirement that integrate the procedural aspect of some of the rights recognized in the European Convention. The effects of these undue delays have a negative impact not only on the effectiveness of the sentence, but also accentuate the deterrent effect that the judicial process tends to have on citizens in general and on victims of violence against women in particular. Thus, for example, the European Court has indicated that the essential objective of Article 8 is to protect individuals against arbitrary actions by public authorities and may include the need for positive actions by the states in the sphere of individual relations. We can guess the enormous importance of this appreciation with respect to facts that historically have been catalogued as or classified as domestic, couples affairs, intimate relationships, and therefore impervious to public attention. This important precision has been highlighted in cases of violence against women in accordance with Article 2 and 8. Thus, the European Court has considered that establishing and ensuring the right of access to justice for women, victims of violence, is an obligation of state parties. This right includes a legal framework that criminalizes acts of violence against women, a regulation of the adjudication and reinforcement of the protection of the rights of individuals, as well as a procedural framework that guarantees rights when the authorities fail to comply with their obligations. The recognition of the right of effective access to courts in accordance with Article 15 of the European Convention in Erie and Ireland in 1981 is one of interest. However, the European Court has specified that the requirement of active conduct on the part of the state must not entail an impossible or disproportionate burden that does not apply to all alleged cases of risk to life. Mention should also be made of the case of X and Y versus the Netherlands. This was the first time that the European Court held that an act of violence against women in 1985 violated a right proclaimed in Article 8 of the European Convention. The European Court understood that the positive obligations implied by Article 8 of Convention may require measures for the protection of privacy even in the sphere of individual relationships. Despite being a case in which a minor with a mental disability had been raped by the son-in-law of the headmistress of the place where she lived, in the unsuccessful attempts of her father to have criminal proceedings initiated, the European Court did not enter into an assessment of the possible violation of Article 3, 13, and 14. However, the European Court recognized the existence of the horizontal effect of Article 8 with the possibility of being violated by private individuals when the state has not prevented the attack of this right. Horizontal character also recognized in the MC versus Bulgaria cases. This horizontal character implies two aspects: the obligation of the state to adopt measures to avoid or minimize possible violations of the rights of the European Convention between individuals. And in the case that this violation has already occurred, the obligation of the state to conduct an efficient investigation to clarify the facts and prosecute those responsible. A violation of Article 3 of Convention was recognized in the case of Aydin versus Turkey in 1997. This was the first case of sexual assault interpreted as a form of torture by a state agent to reach the European Court. This judgment recognized the procedural requirements of an effective investigation of the facts, paragraph 103, and linked to the Article 13 European Convention, paragraph 102. Significantly, In Asenov and others versus Bulgaria case in 1998, a year later, it linked the violation of Article 3 European Convention to the general obligation of Article 1 of the Convention. It's in the period beginning in 2007 that the European Convention, the European Court experienced an increase in the number of cases examined concerning violence against women. In addition to the volume of cases, what is important is that the European Convention, the European Court in this period begins to assess the relationship and compatibility between aggressions in the context of the partner or former partner and the European Convention. This new position of the European Court implies a consideration of violence against women and the need to analyze which European Convention rights are attacked when it occurs, as well as to establish the obligation that a state fails to comply with, even in the case of violence by private individual. We note an important clarification in the European Convention in the Tomasic case. A family spouses and their two sons and daughter who turned to the European Court following the murder of their daughter and granddaughter by their former partner and father, respectively. In paragraph 60, it's here. In paragraph 62 of the decision specify the need for an effective investigation. When is an investigation considered to be effective? In case of YWB versus Slovenia in 2014, the Court referred to the NC versus Bulgaria case. It was determined that it must have been able to establish the facts of the case, identifying and punish those responsible for the crime. And it's an obligation of means, not of a result. You can read this paragraph 64, really interesting in relation to this effective investigation. It is interesting to note that the European Court of Human Rights refers to the measures proposed by the Committee of Ministers of the Council of Europe in its recommendation in 2002 on the protection of women against women as appropriate measures. It's the Opus versus Turkey case in 2009. In this case, the European Court assesses the gravity of the facts as human treatment in accordance with Article 3 of the European Convention, declaring Turkey's responsibility for the violation of Article 2 and 3 European Convention for not having adopted the necessary measures to protect the life and physical integrity of the plaintiff and her mother, murdered by her husband. Particularly important is paragraph 192 in this judgment, which recognize the indirect discrimination in Turkish legislation, the passivity of the Turkish authorities in offering protection for the victims, entailed an indirect discrimination. For example, discrimination that occurs when apparently neutral and not discriminatory roles or provision lead to discriminatory practical results. The European Court ruled on a conviction in a case of violence against women in a romantic relationship on the basis of the woman's testimony before the investigating court, since she refused to testify during the trial. The applicant believed that the rights recognized in Article 6, 1, and 3D European Convention had been violated, as he had not been able to question the other party. The European Court declared that these rights have not been violated. This is the case NK versus Germany in 2018. In her 2015 report, the United Nations reporter noted as a criticism of the European Court case law, the inconsistency between some judgments with similar facts and circumstances. She specifically pointed out the inconsistency between the judgment in Opus versus Turkey case and the A versus Croatia case regarding the interpretation of available statistics on domestic violence that indicate a disproportionate affectation of women. With all this above, we can affirm the case law of the European Court of Human Rights has a great impact on the protection of victims of violence against women, specifically in terms of the configuration and requirement of due diligence. However, the European Court's perspective on violence against women has been criticized for its inconsistency and inadequacy in certain aspects. It's also important to highlight this fact, given in 2009, only in this case had the European Court recognized discrimination as one of the cases of violence against women. This interpretation has meant that it has not examined claims based on other provisions of the European Convention, such as at Article 14. This consideration has had a great impact, given that until 2009, the only international obligation of the member states of the Council of Europe derived from their accession to the European Convention in accordance with the case law of the European Court of Human Rights. Also, it's important the characteristics and specificities of this type of violence from a gender perspective, because we have to apply a gender perspective defined by the European Convention of Human Rights, by European Institute for Gender Equality, as the systematic way of exploring the actual and potential roles and the responsibility of women and men and their access to and control over resources and benefits within a particular environment, project, household, community, or other. This gender perspective is pointed out by United Nations in relation to evidence collection, as you can see in the slide. Victims play a very important role in criminal proceedings, but they are first and foremost people. These suggestions you see on the slide are gender perspective measures and techniques to some victims' need. Even going so far as to hear cases such as SW versus United Kingdom in 1995, or in the case Talpis versus Italy, a case of gender-based domestic violence, the European Court found a violation of Articles 2, 3, and 14 of the European Convention regarding the violation of the prohibition of discrimination. The European Court stated that the court found that Ms. Talpis had been the victim of a discrimination as a woman on account of the inaction of the authorities, which had underestimated the violence in question and thus essentially endorsed it. It's also important to remark that with the evolution of due diligence as a standard to check the protection of human rights, the United Nations and the European institution has pointed the importance of the levels in the due diligence responsibility. Here, for example, you can see in the slide. As you can see before in the mentioned document, the due diligence standard as a tool for the elimination of violence against women, its cause and consequences, you can see 4 different levels can be appreciated. The level of individual women in relation to empowerment, highlighted by the Beijing Platform for Action, or even related to the protection, personal protection, or the compensation, also including restorative justice in the compensation or reparation. And the level of the community family levels relation to this called cultural negotiation, with this consideration of demonstrate that culture is not an immutable and homogeneous entity. The level of the state's relation to the ratification of instrument, public statement made by government leaders and other useful tools. And these transnational levels that it's very interesting also because it's related with the transnational solution to transnational problems, such as the regulation of migration, the role of transnational cooperation, and that is of responsibility of international organizations. Having said all these previous ideas, it is important to remark the added value of Istanbul Convention. Its implementation has meant legislative modifications, the regulations of different forms of violence against women, jurisprudence under its regulation, policies, responses. But most of all, In our specific topic about positive obligation and due diligence, the Istanbul Convention has added significant value by combining the existing international human rights framework into a single instrument and by establishing comprehensive national legal requirements to prevent, combat violence against women from its causes to consequences. Although not legally binding, the monitoring mechanism encourages countries to align with the convention and prompts better tackling of violence against women. While the requirement of due diligence already existed in international law in relation to violence against women, the convention is the first instrument to include the requirement explicitly in relation to violence. Well, we have this interesting document, as we mentioned before, tackling violence against women, domestic violence in Europe, and you can find, I can access in this link. You can analyze each country and its national case law in order to see if there is a mention to Istanbul Convention. It's really interesting. I suggest to analyze, to access. And then we have, for example, some reference of Istanbul Convention and some European Courts of Human Rights case law. And it's interesting, for example, a recent one, case of Court versus Austria, in relation also to the importance of GRIVIO, the group of experts monitoring the accomplishment of complying with Istanbul Convention. And in relation with the question, what happens if this obligation is not accomplished? Well, we have this important of the work of by GRIVIO, as you can see in this summer school is really interesting. For example, in the case of Spain, we have this recommendation. GRIVIO strongly encourages that the Spanish authorities to ensure the effective enforcement of due diligence obligation to diligently prevent, investigate, punish, and provide reparation for victims of any of the forms of violence covered by the Istanbul Convention and without discrimination on the basis of any of the grounds listed in Article 4, Paragraph 3 of the Istanbul Convention. And in the specific case of Spain, we have this, I want to present you two cases really interesting. The first one is this one in relation to the responsibility of Spain for not protect this girl, this woman and her daughter. We have the importance resolution of CEDAW in relation to this case. The fact of this case related to an 11-year long process of seeking protection and justice. This woman, Angela, suffered gender-based violence and fled her home, taking her daughter, Andrea, with her. The situation of violence continued for years, during which she showed protection for herself and her daughter from authorities. Among other measures, she requested that her daughter's visitation with her abuser be monitored. Despite more than 30 complaints filed, the court, based on the psychological reports, allowed the visitation of the child with the abuser to be unsupervised. As a result of the negligent action of the authorities, Andrea was murdered by the abuser during one of the unsupervised visits when she was 7 years old. After Andrea's murder, Angela, her mother, sought recognition of the state's responsibility for her daughter's murder. After exhausting all remedies, domestic remedies, Women's Link brought the case before the United Nations Committee on the Elimination of Discrimination Against Women, and we have this sentence so relevant. Also, the second case of the responsibility is this one. The National Court condemns the Ministry of the Home Affairs for inadequate protection by the civil ward for a complaint of gender violence who was murdered. And this points out the importance of this protocol for forensic risk assessment, urgent risk assessment of gender-based relation to these indicators, and this result: an assessed risk, low risk, medium risk, high risk, or extreme risk fails in this case. Also, as a researcher, I participate in this report of this European project called RETREAT in relation to the reparation of victims of sexual violence. You can find this report in English in this link. The report is called Drawbacks Faced by the Victims of Sexual Crime at Each Stage of the Criminal Proceedings, Spanish National Report. I think that it's important because this kind of project is important to determine the circumstances of the victims and how affects the criminal proceedings. To conclude, I would like to highlight some challenges in relation to, first one, this public and private dichotomy. One of the main obstacles to the protection of women's rights has been attributed to the rule of public-private dichotomy in international human rights law, which was conventionally premised on the liberal minimalist conception of the states. The due diligence standard has helped to challenge the liberal doctrine of state responsibility with regard to violation in the private sphere. Also, we have the identity politics at the local levels. Identity politics based on the claims made by collective entities have been contested public state discourse for the legitimate right of representation of individuals, while such claims have been perceived as manifestation of pluralism and multiculturalism, and therefore as consistent with social and cultural rights. In practice, they pose a major obstacle to universal human rights guarantees, particularly as women are perceived as bridges of cultures. Cultural relativism serves as a major barrier to the implementation of international human rights standards and as a justification for violation of women's human rights. And also the global restructuring with the so-called new geography. The state is no longer the only site of normativity or the unique subject of international law. We have intergovernmental organization, international non-governmental organization, multi-canal corporation, financial institutions, and the need to reimagine the standards so that it responds more effectively to violence against women in the full implementation of generalized obligations to prevention and compensation, and the effective realization of existing obligations to protect and punish, and in the inclusion of relevant non-state actors as the bearers of duties in relation to responding to violence against women. Well, I finished with this recommendation of these two documents, so interesting, and this website that you can find many information related to United Nations and victims of sexual violence and violence against women. I conclude here. Thank you for your attention.
Thank you very much for your presentation, Ms. Lopez. And now we are move on to the question and answer part. And we got one question, and by clicking the chat buttons, you can read it, but I need to read it firstly because the recording. And by the way, I highly encourage the participants to ask a question. Okay, the question asked by Merve Nur Duymaz. Thanks for the presentation and for the answer in advance. I would like to ask you, do you know any case law of the ECHR which is based on expelling foreigners who accused with the sex crime or forced marriage? And if you know how the court acts on these kind of cases, and how we can protect the balance between the state's positive obligation and the personal rights of the person who was expelled. Is the question clear for you?
Yes, it's a great question. Thank you for the question. Well, we have a very interesting case in Spanish national case law in relation to a foreign who was exposed or give away from Spain because she was condemned previously for gender-based violence. So this is important because in this text document I mentioned before, tackling violence against women and domestic violence, in the national criminal, no, it was not criminal, was an administrative court in Spain, mentioned it in Istanbul Convention in relation to the danger for society if a person is condemned by a gender-based crime. At the sphere of the European Court, I don't remember any specific case right now, but if you want to let me think about, maybe I can remember one case and I can send to you without any kind of doubt. How we can protect the balance between state's positive obligation and personal rights of the person who was expelled. This is the big question, but I think that we cannot forget we are talking about a crime against human rights. So I think that the important thing is to remember that yes, actually, I'm curious about what if there is a danger for the foreigner when we expel him. Yes, I think it's because of the previous conduct behavior against human rights women. I think that's the point. The previous behavior of these men, foreign men, is a danger for human rights protection, human rights of women. I think it's the point. And we are talking about violence against women as a crime against human rights. So we have to be with this sentence very clear. But yes, Merve, I will thinking about this question, and maybe if you want, we can send an email or be in contact. Have a general question. Do we get the lecture's presentation via email? Yes, for me, there is no problem. I can send.
Share her contact address by request. You may request her for the presentation document. It looks like
yes.
There isn't any questions, so it's time to close our session. I would like to thank you for your presentation and support our summer school, Ms. Lopez. And
thank you so much.